Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will
proven.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please, verbal talking. I didn't ask you to interrupt.
Is that correct?
Oh, for Trump's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. We've got some breaking news this afternoon as the FBI has released 4 photos in the search for Nancy Guthrie out of Arizona. We've got those photos for you. I put it on Twitter as well to share as far and wide as we possibly can. They're asking for anybody's help who has information or recognizes anything about the image or the person. If you guys have seen this individual, this is what we're looking for. Let's see if I can. These are the 4 images they released of the individual. We'll tear into that just a little bit more in just a second, but wow, spine chilling. Looks like he came with purpose. Looks like he's wearing gloves. I'd say that looks like he has a mustache as well. You can see that there. A little bit of a mustache showing up. So, and possibly armed. I can't really tell exactly what's going on there. We'll dig into that just a little bit. But welcome back. Watching the video of him now. I haven't looked at the video yet. Let's see, FBI director. Let's see if we can get. I haven't seen a video yet. Just images. Okay, here we go. There's a video. Okay, let me pull that up so you guys can see it. This is the full video. Just 1 second. Shut this one down. Let's go full screen as big as we can on this one, so you guys can see. Here we go. This is the video we have, courtesy of the FBI. Wow. Sees the camera. I don't know what he's looking for. Rocks or something? And he picks up some weeds or some flowers of some sort. Does look like a gun there in his waistband right there, tucked in the front of his belt. Sort of it's an odd way to carry it. But, wow. We're hoping that somebody recognizes the movements, the shapes, the eyes, something about that individual. So, thank you for that update. The gloves that he's wearing appear to be some heavy-duty nitrile type gloves. They look like they're not. I wouldn't say heavy-duty. They're lightweight gloves. They're thin gloves, but they're different thicknesses, and they appear to be the black kind. I don't know. You can get those a little bit stronger, like for mechanics and things like that, stronger than what you might use in a medical profession, or maybe just for painting or something. All right. Where are we? Where are we at? Let's go back here. We're about to go back to court on by about, I mean, like right this very second. Let's see if we can get some audio. Okay, we're not back yet. The door just opened. They're not back, so we'll hold on. We've got audio set up, so anytime something happens, you'll hear it. Okay, let's see. Sorry, the internet is going wild. Brian Anton saying about 10 minutes ago that Savannah Guthrie says they believe Nancy's still alive. But it looks like I was listening to Josh from Portland Confidential, actually from Fox News, and from Fox as a Fox contributor, and he was saying it looks like the officials may have pivoted from believing the ransom notes to not believing it, not believing it's authentic. So plumber's gloves are thicker, says Lizzie. All right, we're going to be going to court in just in a minute. You won't miss anything. We're waiting for for the prosecution to decide if they want to delay in the trial. And if so, how long? The judge has sort of given the green light. If they ask for it, they'll get it. But Greeners flipped the switch. I have to thank you very much, Greeners. We have to recognize somebody here. Just 1 second. Hold on. Let's see who it is. Oh, look at that. It's Kim R. Kim, congratulations. You were first in chat today. We're going to punish you for doing that. We like that you are, but we're going to punish you anyway. You are the internet owner for the afternoon. Everything IP related worldwide is your responsibility. Thank you, Greeners, for reminding us by flipping the switch. Let's see, what else? Let's see. Post this one to make sure everyone gets that. There's another video. See if I can get this other one up. Sorry, I just want to show you all the pictures that we have available for this. This is the other video that's come out. These are the weeds to cover up the camera. Does he have a pen light in his mouth? Is that what we're seeing? Then we also have a few other pictures, a couple other pictures as well that they provided. Let's see. You got this one here. That's all we got. That's all we got. Anyway, I've retweeted those if you want to see them. They're on the Twitter page. The FBI director sent them out personally. He did want to express interest in getting involved and in this one, and so he did. But that's where it's at. Why cover the camera? It seems strange. A couple things seem strange. The position of the firearm. Very strange. That is not a standard position for a holstered firearm. I realize that it's a semi-standard position for generally thugs. Not many people like to carry that way. People that carry concealed. It's not a comfortable position to drive a car in, to have a firearm there, to sit down, anything. It's It's a thug position. I don't know what else to say about that. All right, we're going to be going back to court here in just a minute as we wait for the judge. He said that we'd be back at 1:40, and that is in about 3 minutes. So you don't think it's a legit video? The FBI released it, and they're saying they released it they got it from the back end of these camera systems, meaning the cameras themselves were gone, but they were recovered from the server side, which would mean that there was information saved. And I realize that goes against what we've heard about some of the cameras before, but quite interesting, man. Oh, and there's another. He's slow leaking this stuff out. This is crazy. Bring this one up to you. Here's the last one. Just him approaching with his head down. Looks like he's got a bite light, a light that's triggered by biting. Because it's on and off, unless he can control it with his tongue. That just doesn't make sense. You guys can't see it? How about now? Sorry. You can tell the light, it's not just that he tips down that the light's not visible. The light actually goes off. You can see the change in the shadow beneath him. So much is wrong about this. I just don't know where to start. Wow. Well, possible shoe covers. There's just a lot in that picture. I would say definitely premeditated all the way through. Let's see if we can get. See. The FBI director is still like slowly leaking this stuff out. So we're trying to get more. I didn't see any in color. Did you see any in color? I did not. All right. They look like Merrill hikers. That's a nice brand. Merrill hikers are really good. They're the kind I wear. But I have an alibi, I promise. Okay. Just want to watch and make sure nothing else gets sent out here. Just 1 second. There we go. All right. Whew. Terrifying. Honestly, it's just terrifying. You had to have a car or van close by? Yeah, definitely had to have some pictures. Court TV posted a color photo. They didn't get it from the FBI then, because I got it from the FBI. Let's see. I don't see them having a color photo anywhere. What if they tried to colorize it? We could do that as well. Still waiting for court to come back, so we'll hold tight. Let me see if I can get a good picture.
To the jury, Mr. Decker, can you tell us where we are?
Judge, I think we're ready to continue with the process, with the direct examination of Ms. Caneiro.
Okay. Have we come to an agreement as to when we're going to deal with the stipulation issue?
I think before we leave for the day, we can give that to the court. I mean, I think it's like one sentence. One of us just has to write it out.
Okay. All right. Defense, anything else that we need to put on the record before I bring out the jury?
Not at this time, Judge.
Okay. We can ask the jury to come back out, please.
So using AI to colorize the image gives mixed results. Looks like this. Obviously, it's just guessing.
Good afternoon, everyone. You can be seated.
Good afternoon.
Thank you all for coming back this afternoon. As I indicated this morning, we had a legal issue. So if you want to have a doll, you know, like a Mark Lemieux doll that you want to use to kind of stab at for being late, you can blame everything on me, on nobody else. Sometimes things take longer than expected, but we are ready to proceed at this point in time. So thank you very much for your patience, for coming back for the afternoon. We really do appreciate it. Thank you on behalf of everyone here. We're back on the record with State of New Jersey versus Paul Caneiro. It's indictment 19-020283. Can I have the appearances of counsel for the record?
Good afternoon, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Good afternoon, Judge Chris Decker for the state.
Good afternoon, Your Honor. Monica Castellan on behalf of Mr. Paul Caneiro, who's present.
Good afternoon, Andy Murray for Paul Caneiro.
Okay, good afternoon, everyone. Good afternoon, Mr. Caneiro. We'll continue on with the testimony of Caitlin Caneiro. If she can be brought back up, please.
Let the spice begin.
Just watch your step, please, if you don't mind. I want to remind you, you're still under oath from yesterday, okay? We can continue on with the direct examination. Go ahead.
Thank you. Good afternoon, Katie.
Good afternoon.
So, just a couple more topics I wanted to cover. One of them I wanted to circle back to was I think you testified yesterday about the Porsche Macan.
Yep.
And I think you mentioned it was a loaner vehicle.
Yes.
Approximately how long did your dad have the loaner vehicle for?
I'd say less than a week.
And why did he have the loaner vehicle?
His car was in the shop. I don't remember why.
And with respect to, we also heard a little bit about soundproofing in your house through some testimony. Was the master bedroom of the house soundproofed?
Yes.
And what about the basement?
Yes.
Okay. And to your knowledge, who did the construction of who did the construction of the remodeling and including the soundproofing?
It was Corey's best friend, Tom Z.
And as the construction and the soundproofing was happening, was Corey ever there at any point?
Yeah, he would stop over and him and Tom Z would go get lunch together occasionally.
Now, we've also heard testimony about a little bit about a backpack. Did your dad have a backpack?
Yeah.
And is that something that, did you see him carry it around?
Yeah, he carried it everywhere. It was almost like an extension of his wallet. Like everywhere he went, the backpack went.
And for how long would you say that to your knowledge, your dad had the backpack?
I don't know exactly, but at least since I've been in high school.
So,
that time, around 10 years.
10 years? And just a couple questions about your dad. Can you tell us a little bit about your dad as a dad? Was he a good dad or?
Yeah.
Objection.
It's irrelevant. It's irrelevant. Sustained.
Okay. How about your dad as a brother? How was his relationship with Keith?
It was very good. They were very close. They did everything together.
And what about your dad as an uncle? How was he with Jesse and Sophia?
I mean, he treated them like he treated me and Marissa like his own kids, and he would drop everything for us. He'd always be there. He was very supportive. He was just good to have around.
What about specifically about Jesse? What, if anything, can you tell us about their bond?
They had a great relationship. They had a lot of things in common. Jesse loved history. My dad loves history, so they would do a lot of things like that. When Jesse was learning how to swim at the Silton Club, he asked my dad, who I tagged along with, and we watched his little race when he learned to swim. And then one time, I think Jesse was in preschool, he was able to bring a special friend to show off to his class, and he invited my dad.
Did your dad and Jesse ever do things together, like lunch or anything like that?
Yeah, they did a lot together. When Jesse was bored at home, he would call my dad to hang out, and either Jesse would get dropped off or my dad would go there. But they did a lot together.
That's all I have. Thank you.
Cross.
Here comes Cross.
Miss Caneiro, it sounds like the children, Jesse and Sophia, would have trusted your dad, right?
Yes.
Now, do you recall yesterday there was some testimony where you had sent your Aunt Jen a text message on November 20th in the morning of 2018?
Oh, yes. We're going right for it.
And I think you said you sent the text message at about 10:26 a.m.?
Yes.
And your phone number ended in, it was 7924, is that correct?
Yes.
I'm just going to approach you with D154, which you've seen yesterday. And I believe that was what was shown to you yesterday, is that right?
Yes.
Okay. Now, this message, it's actually on the back page of it. The green bubble here where it says, the text message to her, where are you?
Yes.
Does it show as being read on here?
No.
Just delivered, right?
Just delivered.
Okay. And then I think you said you looked at it later and eventually you saw that it was read?
Yes.
Now, does this appear to be a group text message? Let me ask you this. Do you see these numbers here right before it, the first number?
Yes.
Is that says owner? Is that your number?
Yes.
And that ends in the 7924 number. Is that correct?
Yes.
And then you have Aunt Jen's number here?
Yes.
And then this 848 number. Do you see that number? Mm-hmm. Do you recognize that?
No.
Is that a number associated with EcoStar?
I have no idea.
You don't know. It was in your group text message though, right?
There was no group text message with my aunt.
Okay, well then what is this?
I don't know.
Objection?
Okay.
We talked about.
Overruled.
Okay, let me show you. I'll show you something else. Miss Caneiro, did you have another phone number at the time or another number that was associated with your phone?
Whenever I traveled to Greece, I had a different SIM card.
I know the sound's off, guys. It is what it is.
It was a different SIM card, so yes.
So he has a different phone number?
Yes.
Yes? Okay. And that other phone number, was that 732-268?
Blah, 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 8675309.
Okay. I'm going to show you what has been marked, and I'll show council as S504. It's the first page of the extraction report. First page of the extraction report. May I approach?
You can.
See if I can get this to sync up.
I'm going to show you what has been marked as S504. This is the first page of your extraction report from your cell phone. And let me just ask you, you recall that your cell phone was extracted back in 2018, right?
Yes.
Okay. I'm just going to show you if you recognize this number here. This 7924 number. Do you recognize that?
Mm-hmm.
Okay. Is that your number?
Yes.
And that's the number you texted Aunt Jen from, right?
Yes.
And then this number here that ends in 8977. Wait a second, I'm sorry. It's actually 9357 right there. Do you see that?
Yes.
Okay. That's on the extraction report. Do you recognize that phone number?
No.
You don't recognize that? Okay. I'm showing approaching with S505. If we could take a look, I'm going to show you first D154. This is your text message, right, to your Aunt Jen on 11/20/18? Mm-hmm. Okay. And I'm going to show you.
Say yes or no.
Yes.
I'm going to show you what's been marked as S505. Do you recognize that same text message on here?
Yes.
Okay. And does that appear to be part of a group text message?
No.
It doesn't?
It's not a group text. It's a conversation between me and my aunt.
Okay.
From the previous day.
But do you see the numbers up here where it says Aunt Jen and then it has the 848 number and the other number that is marked 357? Do you see that?
I see it, yes.
Okay. Does that appear to be a group text message?
I don't know. I don't see any other text messages. This is, if you look at my phone, it is a conversation between me and my Aunt Jen.
She caught me a lie?
Let me ask you a couple of questions just to clarify some of the cars that you guys owned. So you indicated your dad owned or drove a white Porsche Macan, is that right?
Yeah, his was a turbo.
Okay, and I think you said his car was actually in for service, so
Yes.
he had a loaner car. Mm-hmm. And the loaner car that he had on 11/20/18, that was also a white Porsche Macan, is that correct?
Yes.
Okay, and it had like the black strip on the bottom doors?
I'm sorry?
I don't remember.
You don't remember? Your mom's car, the car that she drove was a Porsche Cayenne, is that correct?
Yes.
Is that the car she routinely drove?
Yes.
And that's the car your dad pulled out of the garage, is that right?
Yes.
Now, did that car have a remote garage door opener in it?
Yes.
It did, okay. You had an alarm system in your house, isn't that correct?
Yes.
And did you have multiple cameras in your house?
Yes.
So you had an alarm system. Did you also have a DVR system that was separate?
I don't know how it works, but...
Okay. So you had an alarm, though, system that was hooked up to your house?
It was, but it never worked, so...
Okay. Certain doors, like, would beep when you were coming in and out, and then some doors didn't beep, right?
Yes.
When you were coming in and out. All right, so you had that, and then you had some cameras inside your house, is that right?
I know that now. I didn't know that back then.
You also had cameras outside your house, is that correct? And then you had like a DVR box that was located in the garage, right?
Yes.
All right, so I would imagine at night you kept your doors locked, is that right?
Yes.
Now, the doors that would beep when you would go in and out, that would be the front door, is that correct?
Front door, yes.
And then the garage doors?
Both of them, yes.
And was there another one?
Yeah, the back door in the laundry room.
Back door. Now, the French doors and the sliders, they would not beep, right?
No.
You come in and out. And where were those doors located?
The slider doors were in my kitchen, and the French doors were in the dining room.
Okay, and did they lead right out to the backyard?
To my deck,
the deck,
which was in the backyard, yes.
Now, you indicated that your dad's room was the guest room, is that correct? And was that room, if you go up the stairs, would it be all the way to the left?
Yes.
And then next to his room was your room, right?
Yes.
And then next to your room was your sister's room?
Yes.
Marissa's room? And then was there a bathroom after that?
Yep.
And then the master bedroom, right?
Yes.
Okay. And the master bedroom, that was the side that was closest to the fire, right?
One part of the master bedroom. I mean, it wasn't the bedroom, it was the closet and the bathroom.
So it like shared a wall with essentially where the fire was?
The fire started in the basement and it went up this back of my house, which was the master bathroom and the master bedroom, not the bedroom, master closet, not the bedroom.
Okay, so the master bedroom closet was where the fire started, right?
No, it ended in the closet.
Okay, but it was on that side of the house. You
Yes.
understand what I'm saying?
Yes.
Okay.
But the bedroom went all the way across.
Understood. It wasn't closest to your dad's room, right?
No, it was closest to the master and my sister's side of the house.
Got it. Now, your mom, you guys had some Australian sheepdogs, is that right?
Yes.
2 of them?
Yes.
Okay. And I think you indicated, or it may have been indicated, that they were with your mom in bed?
That's where they slept in.
Okay. Did you ever hear them barking in the night?
No.
Now, on 11/19 of 2018, you worked all day?
Yes.
And then you got home at, I think you said at about 6:15, correct me if I'm wrong.
I don't remember the exact time, but 5, 6, yes.
Okay.
That sounds normal.
Were you the last one to go to bed that night?
Yes.
Your sister and your mom went to bed before you, is that correct?
Yes.
And you went up to bed at about 11:30?
Yes.
Now, when you came home, your dad was already up in his bedroom in the guest room, is that correct?
Yes.
Okay, and you did not see him the rest of the night, is that right? Okay, I know you indicated, I think, on direct examination that he was sleeping?
Yes.
Okay. You didn't see him though, so you can't say what he was doing, is that correct?
No, I didn't go in his room.
Now, obviously, you wouldn't be able to see anything or hear anything that he may or may not have done when you were sleeping, is that correct?
What? Sorry.
You were not able to see your dad, anything he may have been doing in the middle of the night while you were sleeping, is that correct? And he was the first person you saw the next morning, is that right?
Yes.
He was the one that woke you up?
Yes.
Yeah, so obviously he was already awake before you were awake, is that correct?
I took sleeping pills the night before, so I did not hear the fire alarm.
Okay. But he was awake prior to you being awake, is that correct?
Yes, I was the last one awake.
Okay. Now, you mentioned on direct examination that your dad kept some of his guns in the unfinished part of the basement. Is that right?
Yes.
Is there like a metal locker down there?
I don't know what it looked like. Like, I know the area, like I would be able to recognize as my basement, but I don't know exactly.
Okay. But his guns were kept, you said, in the basement?
In a locked area, I guess.
And also there was a safe in the garage too, is
Yes.
that right? Okay. But that wasn't the only place that your dad had his guns, was it?
To my knowledge, it was.
You weren't aware of a Sig Sauer gun that was located in the guest bedroom with a laser light in it?
I don't know what a Sig Sauer is.
Do you know what a laser light is?
It's a laser, that's a light.
Do you know what it is or no?
No.
Okay. You don't know what it's used for?
No.
Now, your dad was good with IT and tech-related things, is that correct?
That's what he did for a living, so yes.
And he installed the cameras in your home?
Installed? I wasn't there for it. I have no idea.
Did he set the cameras up in your home?
He used the cameras.
Okay. And would he maintain the cameras?
Yes.
He would be the one to handle anything camera-related?
Yes.
Okay. Do you know that he also installed, and you may know because you were sitting here, Dr. Gold's cameras?
I know that now.
You know that now? Okay. If anyone in the home would know where the DVR was located, the box, it would be your dad, right?
We all knew.
Including your dad, right?
Yes.
He was the one that maintained the cameras, correct?
Yes.
Do you remember an officer approaching you and your father on the morning of 11/20 and asking your dad where the DVR system was located?
I don't remember, but I saw it here. I was here.
You saw it here. You don't remember that, but you remember your dad saying, "Oh fuck, I hurt my hand." Just
yes.
To be clear. Okay. Let's play, if we could, permission to play S78, which is the DVR of that portion of the testimony.
Go ahead.
I'm just going to pause it. You can see the timestamp. Okay. Ms. Caneiro, I'm going to ask you just to watch this, and I might pause it and ask you a couple of questions. You can begin. Can we just have the court volume up, please? Pause it, please. Do you recognize the individuals on the screen or any of them?
Yes, my dad and my mom.
Okay. And whose car is that in the back?
My mom's.
The white Porsche Cayenne?
Yes.
Okay, you can go ahead.
That's me, not my mom.
All the DVD stuff for the cameras and everything in the house. It's in the garage. In the garage? Yeah. Where in the garage?
All right, I just want to be clear. Did you see when your the officer asked you where all of the cameras were located? Did you see that part?
Yes.
And your dad looked at you and you said the garage. Did you see that part?
Yes.
Okay, go ahead.
You walk in the garage and it's all the way up top to the left.
And then the officer asked specifically where in the garage, correct?
Yes.
And your dad looked to you and said,
He was talking to both of us.
Okay, my question was your dad looked at you and said, is that correct?
Yes.
Okay. And then you told the officer specifically where the cameras were located. Is that right?
Yes.
Okay, go ahead.
You have it running right now? I've been having problems with stuff in the garage. You've been having problems with stuff in the garage? Yeah. Okay. I would pick it up actually with all the companies. Okay. All right.
You can actually take this down. Now, did you hear your dad at that point say that he had been having problems with stuff in the garage?
Yes.
And that he had a ticket open with one of the companies?
Yes.
Okay. You had no idea what that meant, is that correct?
No.
Yes or no?
I said no.
It's not correct.
No, I don't. I had no idea.
You didn't know what he was talking about? Because according to you, prior to you going to sleep that night, the cameras appeared to be in working order, is that correct?
I didn't check, but I would assume so.
Okay. And do you recall saying that in your statement that you gave to the police?
Yes.
Okay. That the cameras appear to be in working order prior to you going to sleep?
Yes.
Can I just see D1, 425 to 430, please? D1, 425 to 430.
Did we lose some evidence somewhere?
I'm approaching with what has been marked as D425 first. You were shown this picture the other day, is that right?
Yes.
Okay, and that's a picture of your mom, your dad, and Jesse and Sophia, is that right?
Yes.
And about how old are they here?
I'd say 4, 2.
2 and 4? I'm going to show you what's been marked as D426. Do you recognize that?
Yes.
And who is that?
Jesse and my dad.
And how old is Jesse there?
3.
3. Showing you what's been marked as D427. Is that your dad and Sophia?
Yes.
How old is Sophia about there?
2.
Showing you what has been marked as D428. Do you recognize that one?
Yes.
That's your dad and Sophia, right?
Yes.
And how old is she there about?
3.
3. Showing you what's been marked as D429. Do you recognize that?
Yes.
And what is that?
Jesse and my dad.
Okay, and about how old is he there?
5.
5, okay. And then I'm showing you finally what's been marked as D430. Do you recognize that?
Yeah.
And is that Jesse and your dad?
Yes.
And about how old is Jesse there?
5.
When Jesse passed away, he was 11, right?
Yes.
And Sophia was 8?
Yes.
Okay. So of the photos that you chose to sample for your dad's special bond with the kids, they were older photos, is that correct?
I mean, yes, because that's all we have.
Older
All I
photos?
have. Yeah.
that your dad and your Uncle Keith were close, is that correct?
Yes.
Were you aware that they were so close that your dad was actually the trustee for your Uncle Keith's life insurance trust?
Yes.
You were aware of that?
I'm aware of that.
You were aware that they spoke daily, I believe you said too, right?
Yes.
Okay. Were you aware that your Uncle Keith actually called your house line on the night of November 19th of 2020?
I was at work, so no.
So you were not aware of that? Were you aware that your Uncle Keith actually spoke to your mom once that night?
I know now, but no, I was not aware that day.
When your dad told you about the 4 text messages that Uncle Keith sent him in the middle of the night, he didn't tell you about those 2 phone calls?
No.
No. And by the way, the 4 text messages, when did your dad tell you about that?
That morning?
About when?
9:30 or 10.
Your mom, she did not work outside the home, is that correct?
No.
Do you recall her ever working outside of the home since you were born?
Yes.
You do, okay. About how long did she not work outside of the home for?
Probably since I was in 1st grade till after this.
Okay. And your dad was the one who paid the bills, is that right?
I have no idea.
Okay. You're not sure?
No.
Okay. Just speaking of bills, you guys had, there were 2 Porsches that we heard about that your parents each drove, is that right? And then what kind of car did you drive?
I drove a Porsche Carrera S.
Okay. And how about your sister?
Jeep Wrangler.
Okay. Did any of your family members drive an Audi?
No.
No?
Oh, wait, Keith.
Keith
I had an Audi at one point. I don't remember if he had it then,
In
but...
2018?
Okay, no.
Did your dad pay for Keith's Audi?
I have no idea.
Now, you testified on direct examination that when you were about halfway down the stairs, you remember a loud bang, right? And yes, and then your dad saying, quote, "Oh fuck." Do I have that quote right? Or "Oh fuck my hand."
Yes.
Is that right? Okay. When in the last 7.5 years did you remember that little tidbit?
The whole time.
Because you didn't seem to remember it when you gave your statement back on the date that it actually happened. Right, it's not in your statement?
It's not in my statement, no, because I was asking to leave, and they kept telling me that my cousins were okay and they would take me after my statement, so I wanted to get through it.
But 7.5 later, you come in here and you remember it today.
Why would I forget that?
Kind of like 7.5 years later, you decided to check the status of your Aunt Jen's text message, right?
Yes.
What prompted you to do that, by the way?
Because we were talking about her.
You hadn't checked it.
Who was we?
From the time you sent it, though, correct?
Not since that day.
Okay. And then I think you said you checked it a couple of days ago, right?
Yes.
So a couple of days before you were coming in to testify on behalf of your dad, right?
Yes.
Who's we? Who's we were talking about it?
With regard to your dad's hand injury, you didn't actually see him get the injury, is that correct?
I didn't see him hit his hand, no. I heard
You weren't
it.
even sure which hand it was, is that right?
No.
Just the last couple of questions, Ms. Caneiro. You were obviously close with your Uncle Keith, is that right? And your Aunt Jen, and your cousins, Jesse and Sophia.
Yes.
And you're close with your dad, is that right?
Yes.
You guys have always had a close relationship?
Yes.
And you've maintained that relationship throughout the years, is that correct?
Yes.
And you're here today testifying on your dad's behalf, is that correct?
Yes.
And you don't want to see anything bad happen to him, right?
What's worse?
You don't want to lose him too, is that correct?
It's already been gone. There'd be nothing that would change.
Any redirect?
Just can we approach?
So a little bit of spice there, but not too confrontational. Just like 7.5 years ago, you just remembered to look at it. I'm wondering if the defense is asking permission to ask another question here, as she's complained about that she has to. I've never had so many cases where I have to go up to sidebar and ask permission to ask a question. I wonder if this is one of those times. But a little bit of attitude, some spunk from the witness here that is. I'm not sure if it's warranted or not, honestly. Quite interesting. Sorry, there's a meeting going on in my other ear, and I'm trying to listen and ignore it at the same time. So, all right. Who do you think's next? Man, if they're done, it's a whole lot of attitude. There is. There's like gallons of attitude. Do you think she's asking permission to show more pictures of recent pictures of the kids? Let's see. State was very classy in the cross. They were. I think the judge would have. I think they were actually surprised when there was an objection. She turned to walk away from the witness stand, thinking that, yeah, that's as far as I can get. And the judge was like, no, I'll allow it. Go ahead. So the judge was willing to give them more rope than they used, for sure, as far as the lead goes. And not just leading. They can obviously lead on cross, but the scope of the question was more permissible for, I think, than the judge. The judge, I'll say this one more time, the judge thought that this whole issue was a bigger deal than the state did. And the judge thinks the state should think it's a bigger deal than they do. State comes back and says, no, we don't need a break. We're good. We're just going to go ahead and try the case. And they're probably going to get a conviction. There's a lot of really bad evidence that points the finger at Paul. But, yeah. Not sure. Do wonder what's going on right now. Don't believe her about the group text. Yeah, the group text, she showed her the group text. And there's like, what's these other numbers on top? Wouldn't that be a group text? I don't know. I'm not sure. Don't think it was. Has the other daughter testified? No. But if she does, that would be interesting. I don't know why they didn't ask who was we. Who was we? Probably because if she said my attorney or the attorney, there might be some, I don't know, privileged communication if she has her own attorney there. But if the defense asked her to look for that and then didn't turn it over, that would make things a little more interesting. If I would be a daughter of an alleged killer, I would check my attitude. Just saying. Well, it's charged, but not convicted yet. Not sure where this is going. Well, they're almost done. They're almost done. She might be off the stand right here. I don't know if they're going to ask any more questions. I hope they do, because I want this exchange to continue. We've seen previously in this trial that defense and prosecution have a little, like a cat fight ending to asking witnesses questions. So nobody wants to let the other side get the last word in. And so we might see a little of that, especially because we've just had a spicy period of time before this where defense got sort of slapped a little bit. They're trying to regain some ground here. Let's see. Sorry, they're asking me for something. I have to give them really quickly. There we go. All right. Still continues. She's ignoring her father. She's not looking. Jury's not liking Katie. Yeah, I think she came across as unlikable or not very likable. Sorry, I'm trying to keep that quiet in the background. Some of her attitude just seems a little strange. As an adult child living at home, and her possessive way of talking about things at the home. My pool, my deck, my house. I realize as a child that comes across and it seems normal. Once you have an adult living at home, there should be some sort of division there, right? There's a point where it's like, I'm living at my parents' house. You draw that distinction when the world in general expects you to not be living at your parents' house, right? And I realize that, I mean, situations come up and you have to do what you have to do, and it's wonderful to be able to rely on family to get your feet back under you and things like that. That happens. That is very real. But she's very, I would say entitled might be a good word for that. All right, attitude is a trait that everyone is born with in New Jersey. Okay, we've had a couple comments about New Jersey as well. My kitchen. It might be her house now. This is true. It might be her house. Defense is not going to get a mistrial. No, there's nothing that's happened here that would justify a mistrial for defense. Nothing at all. Yeah, I don't think it would even qualify for prosecution to get one. So. I'm put off mostly by the fact that she's testified so perfectly for her dad that all the evidence matches up, that there's an answer for everything. The my deck remark, yeah. We're going to just listen to the silence here as we wait for the sidebar to end. These sidebars have gotten quite lengthy. I have to type some more, I'm sorry.
Whenever you're ready.
Just a few follow-up questions. Starting with the text message with your Aunt Jennifer, do you still have that text message in your phone?
Yes.
As you sit here today?
Yes.
Do you have your phone
earlier
with you?
today, did you have an opportunity to show it to the prosecutors?
Yes.
Okay. And from what you could tell on your phone, is it a group message or not?
It's not a group message, and if it was, you wouldn't be able to see that it's red. Group messages don't work like that.
Obviously, you didn't have access to your extraction report, correct?
No.
Now, you were also asked on cross-examination about the cameras in your house.
Mm-hmm. Yes.
And in your statement to the police, I think the prosecutor asked you, to the best of your knowledge, or they were working at the time.
Yes.
Okay. Did you specifically check your cameras the night before?
I said, no, I didn't. I wasn't one to check my cameras ever.
Okay.
That's something I did.
So when you told the police that your cameras were working, what did you mean by that exactly?
I mean, I wouldn't see why they wouldn't be working.
Okay. But was there, returning back to your testimony about the 18th and what was happening earlier that day,
We were having issues with our Wi-Fi that weekend leading up, and I don't know if it was resolved. I went to work the next day. I wasn't there all day.
And the prosecutor also talked to you a little bit about, I guess, whether you ever heard your dogs barking at night.
Yeah.
At the time that, and during the overnight hours, where were the dogs?
In my mom's room.
Okay. And did you mention earlier, is that the master bedroom?
That's the master, yes.
And is the master bedroom to some extent soundproof?
Yes.
And the last thing I want to ask you about is the prosecutor asked you about your statement and things that you didn't maybe mention during your statement. And I think you started to get into it, but what were the circumstances that you were giving, under which you were giving that statement?
I kept asking about my cousins, and I was being told that once I gave my formal statement, I would be brought to them at wherever they were located, whether it was a local hospital somewhere. And I had no idea what was going on. I had no idea anything about that day, and my statement was a basic statement. I was trying to get out of there. I wasn't sitting there going, no one was telling me anything. They just asked me what happened that day.
What's your attitude? I briefly
said what happened that day.
Did you know at the time what was important or not important to mention?
I had no idea what was going on. No one was giving me answers. I kept asking to leave. I kept asking to find people. I kept asking what was going on, and they would just move past and say, like, we'll answer everything when you're done.
That's all. Thank you.
Recross.
Very quickly, Ms. Caneiro, the DVR system that your cameras were hooked up to, that was actually and Wi-Fi would not have affected it. Is that correct?
I have no idea.
You don't know? Okay. And then just in terms of you being at the police department, and you indicated they wouldn't let you leave, right?
Yes.
It's fair to say there was a fire at your house, right? At that point, there had been a fire, and then there was a fire at your Uncle Pete's house, right?
Yes.
It was important for them to figure out how these fires might have started and who could have started them. Is that correct?
Yes.
And your safety was also important because at that point,
my safety. I was having an asthma attack and they wouldn't let me get my inhaler.
Can you wait for her to finish asking the question before you start responding? Go ahead.
Judge, I'll ask it a little differently. At that point, you guys didn't know who, if anyone, could have been targeting the two families. Is that correct?
Sure.
Thank you. I have nothing further.
You can step down.
Sure. Sure. Wow.
Defense, call the next witness.
We have another sister. Let's see if the attitude runs in the family.
On the Bible, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Once you're seated and comfortable, can you state your full name for the record and spell your last name, please?
Marissa Caneiro, Caneiro.
Okay. Ms. Caneiro, I just asked you to speak up. You probably heard me say that a couple times. Just speak up so juror number 15 and 16 can hear you. Go ahead, counsel.
Good morning, Marissa. Good afternoon, Marissa. Can you just introduce yourself briefly to the jury?
I'm Marissa, and I'm Paul's youngest daughter.
And we heard a lot yesterday from your sister Katie about what transpired on November 20th of 2018. So I just want to focus you in on one specific thing that happened. At a certain point, were you at the police station with your family?
Yes.
And during that time, were you taken downstairs to a conference room?
Yes.
And while you were in that conference room with your dad, did you learn any information about what was happening with your family?
When we were alone, me and him.
Yeah, here, I'll back up. At some point, are you in the conference room with your entire family?
Yes.
Okay. And thereafter, were certain members of your family taken out, and were you left alone with your dad in the conference room?
Yes. My mom and sister were taken out of the room, and then it was just me and my dad in there.
Okay. And when it was just you and your dad, was there a point in time where you learned information about your family?
Yes. A police officer came in, and He told me and my dad that.
You're saying, I'm sorry.
Just say.
Did you learn what happened, just without saying what was said, did you learn what had happened with your Uncle Keith and Jennifer and their family?
Yes.
And did you learn that they were deceased?
Yes.
Okay. And can you just describe that moment that you learned that and what your reaction was and what your dad's reaction was?
Relevance.
You can answer as it relates to your dad.
When they told us that everyone died, my dad was really upset and crying. He fell to the floor, and I was sitting across from him at that point. So I got up, and I was on the floor with him, just holding him. He was crying a lot, and my shoulder was wet. And then eventually they told me I had to leave the room as well. So I don't know what else happened.
When you were in the room with your dad and he was upset and crying on your shoulder, did you say he fell?
Yeah, he was sitting on the chair and then he fell to his knees. So I went over there and I was just holding him up.
And about how long were you on the ground with your dad before you were taken out of the room during this time?
Maybe 3 to 5 minutes.
That's all I have.
Ross?
Just a question. When you were in the police department, ma'am, you were allowed to keep your cell phone on you, right?
Yes.
Okay. And all of your family members were allowed to keep their cell phones. Is that correct?
Yes.
Okay. And then eventually you ended up giving a statement. Is that right?
Yes.
Okay. And then you left that night, correct?
Mm-hmm. Yes.
I have nothing further.
Let me step down.
Can I ask a follow-up?
Sure.
Did you have cell phone service when you were?
No.
Nothing, Josh.
You can step down, thank you.
That was quick and drama-free.
Okay, call the next witness.
Can we approach?
Okay.
Okay. That long delay. Are they done? They've got to call more people. Paul's definitely not taking the stand. They call his wife? No. Did we call anybody that the state's called? Don't think so. So who's calling all the sidebars? That would be counsel, but it may be at the judge's instruction. So. Let's see. Looked like she was going to say we rest. It looks like she's done. I agree. The wife, the question is going to come up because they've talked. Oh.
Hey, research.
Don't do any research. The judge tells the jury, and the jury steps out. Are we having a break? Or just a breakdown? Nice blue
All right,
backpack.
back home, 5 minutes.
It's a 5-minute break. Yeah, you're trying to keep it out. That's my other meeting I'm listening to with this year. 5-minute break is pretty quick. That's not. It could be a witness not here yet. That's very possible. Don't think it's a colloquy. No, this is a break. So I'm thinking that the plea. Can you imagine going this far in the trial and then taking a plea? Oh man, 5 minutes is a quick little break. think it's time to possibly play a song, but I have to play it from a different computer. Which one? Can't play it from this computer because that's the one running my meeting. Change the subject. What about getting a hedgehog? Oh, and I've held a hedgehog. Caught one while I was over in Thetford, England. Caught one in a live catch trap. We were having some trouble with what we thought was some troublesome animals getting in our garbage, and a hedgehog got in there, which is not a troublesome animal at all. They don't jump and climb in garbages at all. But so we got it out, and I held it for a little while. They're incredibly cute, and I guess they have fleas. So, judge sounded a little displeased. He would be upset if the defense did not have their witnesses all lined up. Think of how much time the jury has just sat there in the hallway or in the jury room waiting for the court to get underway. Judge doesn't like wasting their time at all. We want Corey. Let's bring Corey. Oh, man. You got to feed them live larvae. Can you make a groundhog a pet? I don't know. Didn't see his wife while the girls testified. Maybe calling her. We did see somebody get kicked out of court. We don't know what it was for. It might have been like a phone violation or a ringer or a beep or something. What does Mrs. R.A. say about pet options? You can get one when you own your own home and live there. That's what she says. She's highly allergic to many types of pets. Corey. You guys are chanting. My camera, my house, my pool, my car. Did I miss anything from Sassy Daughter? No, that's pretty much it. The attitude she had with the police when they're asking what happened this morning. Like, your home just burned down. And she's like, I need to get to work. I've got to get out of here. I don't have time for this. Really? What do you have time for? A desert tortoise would outlive me. There's no way. Corey was there yesterday. I don't know. I haven't seen him. The messages are acting a little funny today. YouTube's acting up in a big way. So can't find the DNA song. What's it called? Your Honor, in my expert opinion. Is that the one? Oh, it's because I didn't publish it. DNA song. Okay, it's there now. Go on the same link. It'll be there. All right, Janice McDivitt, OG, 21 months. Glad for being able to watch the Spice yesterday and today. I'm glad we got Spice. It's been a little bit slow at parts, so. YouTube is adjusting its algorithm based on Greener's lack of comments. Greenersitis. Talk more, Greeners. Fix it. Sleeping yesterday. I was tired yesterday, but I got so much sleep. I went to bed probably 6:30 last night. Slept just like a 2-hour nap, and then woke up, went to bed again at 10, and slept till 6. So I got plenty of sleep last night. Court is like a box of chocolates. Judy, I'm glad you like it. Thank you. This is the only one we're going to allow. YouTube's having some problems with comments today. We're doing the best to handle it, but Did they stop taking pictures of Keith's kids past 5 years old? It seems like they would at least have some while they were older, unless maybe the relationship broke down a little bit. Had to pet sit my neighbor's turtle named Henry. What's involved in pet sitting a turtle? A lot of waiting, I imagine. Yes, I saw what it was. It's the only one we're going to let slide. Kathy Lou, I don't know for sure how Lawyer Lee runs it, but you can have a blocked word, say like liar. You can block that word, and anyone who types something with that word on it, it never even shows up. The mods won't even see it. So if you guys are finding that your comments are being deleted consistently, like you type something and it just doesn't show up ever, it never even flashes on the screen for a split second before the mods catch it, it's probably because you're using one of those words. And I would do one of two things. Actually, I'd do two things. First, I would read in my head what it is and see if the comment is being mean to somebody or distracting from the conversation. And if you feel it's not, I would reword it and just try different words, but make sure it's adding to the conversation, not being mean in any way. You can say lying liar face. Yes, that's basically how the commentary editing works. See, we allow liar up on the screen, but if it gets abused, I can add it to the list of words. Okay, let's see. Oh, who gets to see the banned word list? Am I the only one? I thought did I post that somewhere? Mods, you can tell me. Did I post the banned word? Red Pen has it. Okay, Red has the list. And it's not used for making rhymes. We don't recommend that. But a short break. I did post it. Yeah. It's got all the words in it. I mean, if you can think of a bad word, it's probably on there. I remember when we didn't have any banned words. Honestly, I don't think any of Paul's witnesses have helped move the needle, the guilty needle. Yeah. I need to see the list. Conveniently publishing a new ebook on Amazon, says Screeners. Behind the scenes. An RA expose. Looks like the judge might be coming back here. Doors opening. Listen for audio. Here we go. He's back. Let's see what's happening. Defense. Judge has a headache. He might have just taken some Excedrin.
Okay, Ms. Vasselon, what is your pleasure?
Judge, at this time, the defense can rest.
Boom!
Once the jury's brought out.
Okay.
They're done.
Caneiro, can you stand up for me?
They're done.
Okay. Mr. Caneiro, there's a charge, a model charge that can be given, but it's truly your decision on whether that I give this or not. It's titled Defendant's Election Not to Testify. It says, as you know, defendant elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at your verdict the fact that the defendant did not testify. That fact should not enter into your deliberations or discussions in any manner at any time. Defendant is entitled to have the jury consider all evidence presented at trial. He is presumed innocent, whether or not he chooses to testify. Have you had the opportunity to speak to your attorney as it relates to this charge?
I have.
Okay. And what is your position? Do you want it read or not read?
Read to the jury.
You want it read?
Yes, please.
Okay. And that you've had enough time to speak to your attorney about that?
Yes.
All right. And then after full consultation, you want me to read this charge?
Please.
I will read it. Okay, thank you. Thank you, sir. All right, ladies and gentlemen, so what our plan would be, is there going to be any rebuttal?
No, Judge.
Okay.
No rebuttal.
With that being said, what I will do is
closings
I'll bring
tomorrow.
The jury back out.
Possibly.
The defense can rest. The state will then indicate that there will be no rebuttal. At that point in time, we have already started with the moving of evidence. We'll continue on in that process. We'll go over the jury charge for the last time, and then we'll be ready for summations. Not today. Can we bring the jurors out, please?
1 second.
Yes, please, if you don't mind. Forgot to stand up. There you go. I've got you. Everybody can be seated. Thank you. Okay. At this point in time, what is the state's preference, or the defense's preference with moving forward? Any other witnesses?
No further witnesses, Judge. We rest at this point in time.
All right. So the defense rests. Will there be any rebuttal from the state?
Judge, there will not be any rebuttal.
Okay. So, ladies and gentlemen, here's where we are. We're at a time where all the testimony has been concluded. One area that still is outstanding that's going to be done now outside of your presence, you will not have to sit here for it, but I decide, remember all the exhibits that you've heard about through the course of the trial? The court makes a decision on which actual exhibits you have in the jury deliberation room at the time that when you start your deliberations. While you may not have every single exhibit that was mentioned, you would be able to consider the testimony of any and all exhibits. It will only be the exhibits that I give you or the ones that you're allowed to physically have in the jury room. So if you're one of the 12 deliberating jurors and you say, Judge forgot to give me exhibit number whatever, I didn't forget. I promise you that. You're going to get what you're going to be allowed to have, but you can always remember the testimony. That's why there's 12 of you that will decide this case, and you can remember whatever you want to remember. So that's number one. Number two, if you recall, what I've said is that at the end of the case, at the end of the summations, I give you the law that you will have to apply to the facts as you find the facts in this particular case. I go over that law with the attorneys on several occasions before it's ever read to you. We've done that a few times. I'm going to do that for the final time this afternoon to make sure that that's also accomplished. So while I'm letting you go, and I know today was not the best for time-wise, I hope that you understand that our plan is we're going to finish that up tonight. Summations will be tomorrow morning. You'll be here tomorrow morning at normal time, which will be 8 o'clock. We'll start at 8:30. Summations will start in reverse order. We start with the defense's summation, then we'll have the state's summation, and then we'll move into the actual charge. It is after that, then we get into the deliberations, and we'll pick, if everybody remembers, then we get to see how we pick alternates in this Monmouth County. Pretty high tech. It's very exciting. Can't wait to show it to you. So with that being said, though, that you're done for tonight. You Don't discuss this case. Now, just because we're at a point where we're done with all the testimony, do not discuss this case. There's no greater time than right now than a need for you to listen, not to discuss this case at all. You haven't heard the summations. You haven't heard my charge. Only deliberation is done in that jury room with the door shut, and that's for you and you alone when you decide to start your deliberations. So with that being said, don't discuss this case. Don't do any research. I hope you have an excellent night. I'll see you tomorrow morning. Please be safe. Thank you so much.
Are we all done? What's the plan? Are we going to go over the jury instructions one more time? Closings tomorrow. We've got a poll up right now. Make sure you voted in the poll. Do you feel that the state has proven their case against Paul? Sugar Cream, thanks for subscribing to the channel. We do have a little delay time before you can chat. That's just to keep the trolls out. We apologize for that delay, but it will be gone in no time, and can't wait to be talking to you. Sorry, I've got to keep this meeting going to my other ear. So YouTube says I have to do 9 more members-only videos this month. So we're just going to hammer them out.
Give me 1 second, please.
Judge asked for a moment of grace and space to get something done. I think he's looking at the exhibits. Make sure all the exhibits are covered.
Okay. All right. So we're going to go back to the exhibits. We spent a good amount of time on Friday afternoon going through all of the exhibits. Let's talk about
I have a hard time getting it
we
switched
figured
over.
out the photo book for S1 and taking out the photos.
Yes, we were just, the only one was A, I believe, that we hadn't done just to make sure that we didn't use anything else, but that everything else is complete, and Ms. Schmidt is actually just finishing subsection A.
Okay. All right. So the defense tonight, you can take a look at it, or before we leave today, because it's only A. It's not as many photos as some of the other sections. But the plan is to take out the photos that were not identified. Is that correct?
That is correct, Judge, and that's what we've done thus far with all the other portions.
Okay. I'll give the defense time to take a look at the book, to go over it, make sure that they're in agreement with the photos. If there's any photo that is still at issue, that on whether it was identified or not, I have them all marked in my photo book also, and I'll give everybody, I would address the issue at that point in time.
I did have an opportunity to review, I guess, most of the sections, and as a result, I had just some objections to a few of the photos.
Okay, great.
I don't know if the court wants me to discuss.
Yeah, that'd be great. Thank you. So tell me, let's start with B in the photo book then.
Judge, I can just skip to.
And the live stream has frozen. Let's see.
Sections I have are with like the autopsy photos.
Okay.
And the only thing, for example, photo number 7 is, I believe, a photo of Keith's hand and stomach area, and then they have on top, like after that, 7.1 with like some markings. It's really just a circle, I believe, or something to that effect, and so forth and so on. So they have 13, which is Keith Caneiro's head, and it displays 5 gunshot wounds, and they have 13.1, which has certain gunshot wounds, I think, circled, and then they have 13.2, which has more gunshot wounds circled or something to that effect. I don't have it in front of me. I'm just working off of my notes. but they do that for photo number 14, and then they have 14.1 and 14.2. Photo number 15,
thank you so much.
15.1, and they have photo number 16, and they have 16.1 and 16.2. Those are 3 gunshots, including like a gash-shaped gunshot wound on the top of the head. So there's 3 of the same photo. It's just that there's like a circle around something. My position, Judge, well, I'll just keep going. Then there's 17, and then there's 17.1, and then there's 23, and then 23.1, 26, and 26.1.
17 is just the bullet fragments from the brain.
Yes, there's it's a projectile from the brain, but there's, I believe, like there's like blood and brain matter.
Okay.
And then 25 is Sophia, and 25.1. So my position, Judge, would just be that it's essentially cumulative to have the same, and prejudicial, to have the same autopsy photo numerous times. You know, if the state wanted to use the ones with the markings because they're probative in some way, obviously they can do that, but my position would be that the original should be taken out, since the photo with the marking is obviously, it shows the original plus the marking, or alternatively that they just keep the original and go off of the testimony. Everything, all of the autopsy photos that have markings on them are simply like one wound being circled, I think, with like a pink circle. There's nothing initialed or drawn or explained. I don't, the jurors can see that it's a bullet wound for themselves, and I just think to have repeated photos of the same thing is...
So you're fine with the .1s or .2s, so you're just not, you don't want the duplication of the regular photo with nothing on it and then the circles. Is that what you're saying?
That is what I'm saying. And if there's multiple points, if there's like a 16.1 and 16.2, and it's because 16.1 has like 1 circle and then 16.2 has 2 circles, I think that just whatever the final product is of that photo is appropriate, would be my position.
Okay. State's position as it relates to that, if you have the marked up photograph, do you have a position whether it's necessary to have the photos that are not marked up also? And if you do, tell me why.
I'm just trying to evaluate the printer quality, Judge. I mean,
sure, no problem.
You know, there are some differences in the quality of the photos, but, you know, I do see, I certainly would not want to take out anything that was marked up by Dr. Zhang in this regard?
Well, that's why I'm really asking you, do you need the regular photo, considering that I would allow the .1 and .2 or whatever it is if they're circled in the testimony? Or
Judge, I will defer to the court in that respect, but I do think that we obviously went through a process, a significant process of narrowing down and paring down autopsy photos. Yeah. And ultimately, like, I showed like one picture of Sophia Caneiro, which was a horrible picture, and I left it up for like 0.3 seconds. If they feel the need to look at all the photos, that's part of their determination. I would really ultimately say that I think the photos should stay in as is.
Okay. So 7, I should start with number 7. And 7 had slide 7. That it had it's not on the list here. Is it a .1 and is it more than a .1? So slide 7 shows Keith Caneiro's hand. It also shows part of his stomach area with what was identified as a gunshot wound that went through his hand into his stomach area. Actually, through his stomach area into his hand.
It's actually through his lower back, through his stomach, and then through his
hand and outside.
2 entries, 2 exits.
Yeah. As it relates to that particular photo, I'm going to allow 7 and 7.1 due to the fact that that injury in and of itself, the jurors may not remember and I sat through the testimony also and listened intently of that the track wound of that injury. So as it relates to 7 and 7.1, I'll allow it. I find the probative value outweighs any prejudicial effect. There's no significant showing of the body here. There's nothing that leads this court to believe that the jurors would be inflamed by this particular photo, and I'm going to allow both photos 7 and 7.1.
We're going to close the poll while the judge is talking here, so if you haven't voted,
Next
make sure you
photo,
get your
I
vote
believe,
in
that was
very
mentioned
quickly.
was 13. So 13 had, I was testified to by Dr. Zhang, these 4 holes in Keith's face underneath his right ear is a bullet going in, comes out, goes back in and out. And 13, can I see 13.1 and 13.2, please?
Yes, sir.
If you don't mind, that would make my life easier. Thank you, sir. As it relates to 13, 13.1, and 13.2, the court's going to allow 13.1 and 13.2. That provides a framework for the testimony from Dr. Zhang as to the directionality of the gunshot and how he found it and how it went through the neck and then through the face of Keith Caneiro. And it also talks about, it reminds the jury of the third hole right by the ear as it relates to what he found at that location. So I'm going to allow 13.1 and 13.2. I'm going to exclude 13 as cumulative. I don't think it's necessary for that shot. I feel that that photo doesn't provide any further evidential value for the jurors to make the determination as to that track wound of the bullet. So therefore, I'm going to exclude 13. Again, 13.1 and 13.2 are in evidence. As it relates
Welcome, the defense rests and viewers. Thank you for joining us. Thanks for the raid.
As it relates to 14, there's a 14.1 and 14.2 for the same reasons. I'm going to allow 14.1 and 14.2, which shows Dr. Zhang testifying about where the entrance wound and how it goes in from the side of his head through the upper part of his head. The actual gunshot wound and the directionality of it from 14.1 to 14.2, the circles there. I'm going to allow 14.1 and 14.2, and I'm going to exclude 14 as cumulative.
Courtroom really cleared out for this portion. even Paul's supporters are gone.
Same for 15.1. Allow 15.1. And for the same reason, 15 will be cumulative. But I find that 15.1 has probative value to explain where it was documented of where the entrance wound was located and circled. I make the same finding for 16. There's a 16.1 and 16.2. I find 16.1 and 16.2 to be evidential. It shows the wound. It orients the jury as to the testimony as it relates to those specific injuries. And for that reason, I will include 16.1, 16.2, and I will exclude 16 as cumulative. Besides, for 17, which includes the projectile from the brain and how it was impacted as it went through Keith's skull, 17.1 circles the projectiles. However, in the circling of the projectiles, it kind of goes through the projectile and in some ways obscures the actual photo. 17 is a clearer shot of these items, so therefore I don't find them to be cumulative. I find them to each have their own evidential value, and for that reason I'm going to include slide 17 and 17.1. They're both included in evidence. Okay. Ms. Massalone, was that the only area of the photo book, or was there some other area that we needed to discuss? Mr. Decker, I'm sorry I stole your book.
That's okay.
He's like, no, Judge, continue. As long as you rule in our direction, you can have all my books.
Judge, we have no other issue. There was one other photo that we discussed with the state. They're not admitting it, and that's it.
Okay. So the only one that we have left then to discuss at some point is A, after you receive it, correct?
I just reviewed it, Judge. I have no objection.
Okay, so A, as noted, is in. So the final photo book, Mr. Decker, will be where for when summations start tomorrow? Is that the book that you have in front of you?
There's two books.
There's two books.
Yeah.
Okay. So I just want to make sure that final book is in a spot everyone is in agreement with it. I don't want it to get lost for any reason. I don't mean that in a negative way. I'm not saying you guys would do that. It's just making sure that we don't want anything going into the jury room except for exactly what we all agree to. Okay? All right, thank you for that.
Judge, I did previously show the state the photos that we were likely intending to admit. They indicated they didn't have an objection, but I didn't have an opportunity to choose our point ones that we were going to show. So I have them now. It's not too many. I can hand them to the state if they want to take a quick look.
Okay.
See if there's any.
Yeah, we'll have time for that. All right, so I'm going to move things along. I'm going to remind us of what we already have in evidence, and then we can go over, Ms. Wallace, if there's items that I may blow past that we need to talk about, just stop me, okay?
Okay.
All right, so S2 is in evidence. S7 through S12, including the point 1, point 2, point 3, point 4, point 5, and number 12, all in evidence. S17 through S19 in evidence, including proposals A, B, and C. S26 in evidence. S28 in evidence. S29 in evidence, including point 1 through point 10. S30.
I'm sorry. I think the points were in evidence for that.
Oh yeah, you're right, and not the main document. You're right. You're right. Sorry about that. So it's just 29.1 through 29.10 are in evidence, not the overall statements. I apologize. Same with 30. It's just points 1 through 19 that will be in evidence, not the entire statement. The next were the area of S33 through S38. We discussed them. I think we said that 33.1, 34.1, 35.1 were in evidence. However, is there anything else from 33 through 38 that we needed to have a discussion about, or that was being moved or not moved?
No, Judge, we looked at them. We're good with where we left off.
Okay. So it's just 33.1, 34.1, and 35.1. Otherwise, not the entire document. And 36, 37, and 38, there was no .1s on those, so they are not being moved. S40, we're moving in A and B. But that's the only areas. Okay, we had we were going to revisit S42 and 43. Ms. Wallace, where are we with those?
We just spoke to Mr. Murray. We are good with S42 being moved in, but not S43.
Okay. So you're not attempting to move in 43, correct?
That's correct, Judge.
All right. And you're good with that, Mr. Murray?
Yeah, I took another look at 42, and I think that the large bulk of it was testified to already, so we don't have an issue with that.
Okay, great. Thank you. S44 through S53, all in evidence. Next one is S61, A and B are in evidence. The next were the S60 through 65 that we reserved on. Did we come to an agreement on that?
Judge, the state's position is still that those should be moved in. I would note that we did mark, or we did look at, and we put up the index on that, which is what Detective Niglorisi actually drew on at one point. And that index had the dates of 4/13, 9/13, 9/17, and then 11/5.
I'm closing the poll right now.
So I understand, obviously, that's the state's position.
Okay. And the defense's position, go ahead. I know you have objected to it because you said it was confusing, the way that you have to read it. It was a little difficult. But was there anything else that you wanted to add to that?
Judge, if the court is inclined to allow it, then I would just ask that they be like page numbered, so that at least if they do get disorganized, there's some sort of mechanism to put them back in order. Perhaps they can just number them.
That's fair. That's fair. I'm going to allow them in, and I'm going to ask for them to have page numbers. I agree that the page numbers would be helpful. I do find them to be relevant under the circumstances they were testified to. And I do find that under the circumstances the jurors should have them. But can we have Ms. Wallace have somebody do some page markings on these? I know it's going to be a lot to do tonight.
Yes, we could probably put them in binders too. We can even print the index. I don't know if that's something that would probably be helpful, having the index on it as well.
Fine too. Just as long let the defense see that at some point.
Okay. And I was just going to add, if they're going to put it in binders, that makes sense. Maybe like a cover page with the date to organize them by date.
Yeah, that's fine.
Again, our initial position is an objection, but that's
of course.
Our position.
Yep, your objection is definitely noted from before. It's noted again here today, but I'm going to allow
it's
it
overruled.
in. However, I do agree with you that page numbers are helpful. Okay. S66, A and B both in. S69 and 70 both in. Next is S74. all parts of S74, A, B, C, D, and D1, all in. S76, including clips A through D, all in evidence. S78 in evidence. S93 in evidence. S94 in evidence. S96, and I believe it's just B in evidence because the first 911 call was not something that was a hang-up or something.
That's correct, Judge.
Okay. So it's just B. S99 in evidence. 101 and 102 in evidence. S155 through 166, all in evidence. S168 through 177 in evidence. We reserved on 178, which was the padlock Pelican Storm case 2050 with a knife flashlight. If you guys had the opportunity to discuss that again, has that been worked out or no?
I don't think it's been worked out, Judge. It's a locked case which was opened for the purposes of removing the gun and sending it for testing to the state police. We submit that obviously there was a lot of weapons that we didn't utilize in front of this jury, but that is one of the handguns that was tested, and that was the way it was found.
Okay. All right. Ms. Mastellone, I know you objected to it, but I'll allow you to, if you want to object any further now, or if there's anything else you want to add.
Nothing to add, Judge, just objection.
Okay. I find under the circumstances that the jury, because the jury's not going to physically have these items, that it's more of the testimony anyway. However, I do find under these circumstances that not all items were sent to the state police lab. This one was. If the jurors for some reason had some reason to want to see it, it will be in evidence for them to be able to see. I don't know if they even will, but I do find that the probative value outweighs any prejudice to the defendant. Again, for the reasons that these items, as it relates to all of these guns that were located at 27 Tilton, they're not all going to be physically in evidence, so I have no issue with it. All right, S179, 180, 181 are in evidence. S183 through 196, all in evidence. S214 in evidence. S222 is as a continuation of the same argument from before, dealing with this small plastic bin with 6 magazines and 11 finished lowers from basement of 27 Tilton. Ms. Wallace or Mr. Decker, anything else you want to add to that?
Judge.
Ms. Mastellone, I know you objected to it before. I'm just giving you the opportunity if you wanted to say anything else.
Judge, I'm just going to other than the text messages, when we're dealing with the ballistics, since that was Mr. Murray's witness, I'll let him.
All right. So 222, we don't have an objection to.
Okay. That's an evidence. All right. S230.
What reserve on 225, or was 225 previously ruled in evidence? Over objection.
I have it crossed off that I was not allowing it in evidence, 225 or 226.
Okay.
The arguments can be made, but I said no to the actual items going in. 230, 231, A through E, and then 233, up to 242, all in evidence. 256 A and B in evidence. 261, 261.1, 262, 262.1, 263, and all of its subparts A through M, and there was a lot of .1s added. They're all in evidence. 264 in evidence. Then 270, 271, to include A, B, C, D, E, F, and then 271 A1 and 271 C1, all in evidence. 272 in evidence, 273 and 274 in evidence. 285 and its subparts A and B and .1 and .2 in evidence. 299 through 338, all in evidence. 347 in evidence. 375 in evidence. 391 in evidence. 392A, E, and H, all in evidence. 405 in evidence. 407 in evidence. 418 and 419 in evidence. 437 in evidence. 467 in evidence. 474 in evidence. Then we said we were going to hold off on 476 through 480. I don't know if there was any more consideration as it relates to the DNA from the state. I know that the defense is going to be asking for certain items. I'm not saying I'm going to put them in. I'm just saying that they wanted to move certain items of their evidence from their experts. So I'm asking you what your intention is with these items.
I'm just trying to recall what they wanted to put in from their expert.
Mr. Murray, that was your witness as it relates to Dr. Reich.
Well, Judge, there was also the exhibits that were published during Daniel Reed's testimony. I think we didn't really get to those last week when we talked about.
Okay, which ones were you looking at there? So Mr. Decker will be able to argue, or Ms. Wallace, whomever.
That was Ms. Stallone's witness. On cross, she can correct me if I'm wrong, but I would imagine it was 140 through 143.
They were the
S 140 to 143 or D?
D 140 to 143.
Okay.
They were the and the state, when we initially showed it to them, they didn't have an objection. There was nothing additional, I think, that we had, or from his power.
One is the one you wrote on. I think that's 140 and 141, right?
Yes, 140 is Bodie's chart, likelihood ratio chart that I wrote on.
Yeah.
141 is the allele chart that's highlighted. And then we had the two deconvolution reports, which really there was, not the whole thing was referenced, but portions of it. So that's what we were initially asking to be entered into evidence. I don't recall what the state was asking for. I think we wanted an opportunity to confer with them. We just haven't spoken about that yet.
I mean, I'm just struggling with the idea that, I mean, obviously, we want the Bodie results in on that chart, but there's other results that are in reports, and then we just have certain documents just because they're highlighted doesn't make them any more evidential. I mean, I think it's kind
Well, there's writing on 140 that's testimonial, and then there was writing on 140.1, which Ms. Wallace got back up, used the same document, and then we pointed that out. And we made that a different exhibit. I have no problem with that timeline going in for both sides. I think it's fair. It's testimonial on the document. Ms. Wallace, I forget what you marked when you got up and you asked for it, and then we.
On the DNA report, Judge, or
On the Bodie report, and then there was the back of a notepad that was written on. If you guys remember, it was Miss Mastalone's notepad.
Because that was the timeline. That was through Detective.
That's a different timeline?
Yes.
I'm sorry.
It's okay.
Mr. Murray's notepad.
Technically, it's a .1 exhibit because we didn't preserve the notepad as an independent document.
Valid point.
Fortunately.
Right. Why, you don't want all your notes to be put in evidence?
I prefer not.
All right. All right, so your position is what as it relates to the Bodie chart?
The Bodie chart, I'm 100% comfortable with that going in.
All right,
Obviously,
so that's 2.6. That's D140 going in.
And D4, is it
41?
41? I have no issue with the allele chart table going in.
I don't see the value of the deconvolution report because there's areas of the report that was not testified to. However, I mean, the exhibits were shown on the screen. I think it's fair comment by both sides. Both sides use the deconvolution reports, less used by the state, more used by the defense. But I have no problem with those being discussed in detail if you want to discuss them. It's just that the entire report, and there's a lot of areas of the report that was not discussed, and I don't want them getting confused as to what each thing means or and trying to figure it out. So
I agree, Judge. I don't necessarily need the entire report in, but perhaps just the portions that were published.
then you're going to have to redact the front page because there's items on the front page that some were testified to, some were not, as the Gelman-Rubin and the fallout ratio or the burnout ratio. Some of the stuff wasn't even touched.
I mean, Judge, if we had a little bit more time to think about it, then, we could perhaps come up with a solution. I'm not sure in this moment. I mean, again, things that were published, I think, should
go to the jury.
Have access to it. I mean, maybe we could agree that they don't have it back there in the jury room, but if they wanted to look at it, we could allow them to see portions if they had a request.
I don't like that. I like giving them all the evidence. If it's admitted, give it to them. With the exception of ammunition and a firearm or a knife.
Thank you.
Give them the ability to sort through it, find what they're looking for, and give them all the evidence. Let them decide.
Mr. Decker, I don't know if you want to say something.
I guess, Judge, I'm just trying to figure out, I just don't want to confuse the jury on, they're not actually getting the DNA conclusions in some respects. the state police, the actual expert report from the analyst, but then they're getting like deconvolution reports that are part of the analysis leading to a conclusion, but they're just not getting the conclusion. Just because an exhibit was shown or published, I think the way I look at it is if I would have shown Chris Clayton his report and said, let me publish this and have him underline his conclusion, I don't think it would make the report any more admissible just because he pointed that out. I think it would be kind of like a great way to backdoor every expert report. We're all certainly going to talk about the DNA conclusions in summation and ballistics and stuff like that. But if we're going with the expert reports aren't coming in, I think that's kind of where we're at.
I hear you. Go ahead, Ms. Massalone.
Again, Judge, I really haven't had time to think about it, but maybe if just in the event that they ask for a readback, it could be made available to them. If it was something that if it was a specific area of testimony that they were interested in.
Yeah, I'm not going to allow the physical documents in because a lot of it was not testified to. Anybody can comment on it. If it becomes an issue, excuse me, if it becomes an issue on a readback, we can discuss it at that point. But I'm not going to allow it in for now for the same reasons that I didn't allow in other reports from either side, just like I wouldn't allow Reich's report in. I wouldn't allow some of these deconvolution reports because there's so much information on here. I find that under 403 it would be confusing to the jury to fully understand all of it, and I would not want them to go back and trying to do become their own expert in DNA analysis. So I'm not going to allow 142 and 143, but again, if something comes up during a readback, then we can discuss it then.
Should I just ask one question?
Sure, sure.
We didn't get to, I understand the court's ruling on Dr. Reich's report. There was also the PowerPoint presentation.
Yeah, let's take them one at a time. I'll get to you. I didn't mean to jump ahead. I was just using that as an example that throughout all of the state's exhibits, I didn't allow any investigation reports or any other person's reports. I was only drawing the same analysis, but I didn't get to that yet. I didn't know you were even trying to move it. So let's wait until we get there, if you don't mind.
Thank you.
So can we go back to the state so just the record remains clear? Considering that the court is not allowing deconvolution reports, is there any request for 476, 477, 478, 479, and 480 for that example?
No, Judge, under the same ruling, I would suggest that would be consistent.
All right, so no to all of those. And again, the free game, it's free reign to argue whatever you need. And then I think the only other one was the photograph of the defendant and his daughter, 501. Is that being moved or is that not being moved? I don't recall.
No, Judge, I don't think that foundation was properly accepted by the court.
And anything that happened today in any of the exhibits that occurred, or do you want to wait to hear what the defense is going to request before you get into that?
I'd wait.
It was 502 through 505, I would assume, because the last one I had was 501.
We'll be moving, seeking to move 504 and 505. This is 502 and 503. Okay, thank you. Yeah, so the state would be seeking to move 504 and 505.
504 and 505 deal with the cell phone?
Yes, that
and
is.
The extraction?
Yes, that's correct. 504 is the first page of that. And then 505 is another page that was shown.
Okay. So my question to you is that
that's the text message? And
again, I understand how we got to where we are today, but we don't need to go back to that from this morning. But if it was an agreement not to put in the phone, the screenshot of the phone where it says it's red, how do I put in 504 and 505 after the testimony is already out there, but not the reports?
Yes, I didn't realize there was an agreement not to put. I don't think I understood that, not to move in the screenshot.
Well, it wasn't, and I know we discussed it, and I believe what Ms. Massalone said, and I will not put words in her mouth, she can say whatever she remembers, is that it was my understanding that she was not intending on doing it. However, if something came up, she would let us know at sidebar that there was some questions that she wanted to ask, which she did not do. So with that being said, that is the reason why that I'm just wondering, considering we did not put any report in about this, if that's your plan. If you want to put it in, then I'll hear from the defense.
I mean, I think the state, I think the state would be seeking to move that in. There was testimony about the facts of the text message itself. And this was shown to the witness. We marked it, we showed it to her. So I think for purposes of completeness, the state would be seeking to move these two documents in.
Okay. Hear from the defense as it relates to 504 and 505.
Judge, the court is correct. I mean, the defense was never intending to use the screenshot, but rather to simply elicit her testimony, which reflected her recollection of what occurred. I did not question her on the screenshot, and I sort of found out in live time that the prosecutors were going to question her about the group chat, which they did, and she wasn't able to, I guess the foundation was not really laid as far as the admissibility because she didn't recognize it. She's never seen it before. The prosecutor asked her, does this appear to be a group chat? And she says no. And so my position would be that either none of it comes in, which that was what I assumed was the agreement as well, or that in fairness they should all go in because, again, it goes to her credibility and completeness. You know, she's not lying when she says that it is a text message between her and her aunt that says red. And we know that she's not lying because she testified to it under oath. We have a screenshot of it, and the prosecutors themselves saw the screenshot. They saw her phone earlier today where she showed it to them. If they want to suggest that it's a group chat as opposed to a single screenshot, if they want to show that that's what the extraction shows, then fine. But then we should also be able to show what this witness was looking at, her own phone and the screenshot. So I think as a matter of completeness, it should be nothing, which was originally what we assumed, and I didn't question her about it, or it should be all three items.
Anything else?
No, Judge, I'll leave it in the court's discretion.
I think that the testimony was clear. I'm not going to allow the document in because I'm not allowing the screenshot in under these circumstances, but the testimony is out there. The document can be referred to as part of your summation as to to remind them of the testimony. You know, I'm not sure if I actually agree with the defense that because she testified under oath that she was telling the truth. I don't know if she is or she's not. All I know is what the extractions say. She saw extractions from the defense. She recognized it. She saw an extraction from the state. She doesn't recognize it. All I know is that I'm not going to allow them in, but I will allow the state to comment on those items, 504 and 505. So they will not be in evidence. Now let's go to the D.
A little win for the defense.
Judge, I do have a concern about, I don't know what the state's comments would be as far as that exhibit because, I mean, it would have to be consistent with the testimony. Otherwise, the state is essentially testifying. So I'm not sure what that means, that the state can comment on it. I mean, again, I think that the defense and the state could meet and confer, and we could come to an agreement if we had a moment. But, you know, obviously it wouldn't be appropriate for the state to be testifying to things that weren't testified to by this witness in their closing. As to the witness's credibility, Judge, again, that the state saw the phone, so I think that speaks for itself.
I think the document has to come in.
Is that what you just said? I didn't see the phone. I have no idea what the phone shows and what it doesn't show, but it's not, I don't need to see it. It's the back and forth from you all. I've made my ruling as it relates to this. If the state and defense want to confer as to what they're going to say, they're experienced prosecutors. I told them what they can and they can't say. It's within the testimony, and they know what she said and what she didn't say and how it was confronted and what the report, what questions were asked about the report. So I'm going to leave it at that. I'm not telling them what to say or what not to say. I'm not going to get in the middle of that because that's a different issue that I want to stay away from. So
he's talking about an impeachment issue.
I'll leave it at that. All right, let's go to the defense exhibits. Mr. Murray, what I had, tell me if I'm wrong, your first exhibit that you moved in was D55.
That's right.
Okay. And then we had D64.
Yes.
D71 and D71.1.
Yes, those were published exhibits that we were moving.
Okay. 106.
106, yes.
Okay. 114.
Yes.
122.
Yes.
And then we're to what we discussed. Now, from your DNA, tell us which ones you're looking to move.
So I think there's an agreement on D140 and 141.
Okay.
Those were the marked up exhibits.
Is that correct, Ms. Wallace?
That's correct.
Okay.
The court's ruled on 142 and 143.
Right.
Then we had D150, which was published, which was the PowerPoint from Dr. Wright. Now, obviously, we're not looking to get in his report, but I think similar to the testimony of Detective Bassender, where, you know, it's not the entirety of a record that's coming in, but a demonstrative chart that the jury is going to have available to them. You know, I kind of see the PowerPoint to an extent the same way as those charts, so we're planning to offer that.
Okay. And that was, tell me the number, because mine's, your exhibit list stops at 144 for me.
Oh, so that's D150.
D150. State's position.
I mean, I just think it's another report that he drafted. I mean, we're leaving out a lot of DNA conclusions in this case. They're not getting them other than what they heard from the witness stand and what they're going to hear from me and or, you know, defense counsel tomorrow. So I just think it's kind of a little selective in the sense that they get some results and not the others.
Can I see the PowerPoint? You have a
Show me
physical
the
copy
money,
of that?
says the judge.
Summary of voluminous documents. Yeah, I mean, just for the record, the Bassender charts were under, I think, Rule 1006, summary of voluminous documents. It's just a demonstrative report.
Okay.
I do have it here, Judge. You know what? It might be in our that room. It might be in our the other box that I brought this morning. All right. I have it here. I could either go get it now or.
Why don't you put it on the screen?
Show us, says the judge. Not sure if we'll get to see this. I'd like to. It's a very stout HDMI cable.
All right. This is page 1?
This is page 1.
All right, let's go to page 2. Page 3.
It's very durable. It's just not flexible. Not good for laptop ports.
Page 4.
Sorry.
Page 6. Page
Bailiff
7.
is gulping down that water.
Page 8. Page 9. Page 10. Page 11. Page 12. Page 13. Is this already in a clean copy?
It's already in a marked up copy, I believe, Judge.
Okay. This is what? This is 13?
This is 13.
Go ahead. Page 14. Page 15. Page 16. Page 17. Page 18.
It's 17 to 17.
Okay. Can you go back to page 5, I believe?
Yes. This is 5.
4. Let me just see. Three. And 2. Okay. Okay. The court's position as it relates to this document, this PowerPoint that was used by the defense expert in this case, which argues that, or that the defense's expert indicated that while some of the results were reliable, it also talks about
Judge has a headache.
How there were certain areas that potentially of another person being involved in this, or another person's profile was at the scene. The court finds, as it relates to third-party guilt, it's going to allow only certain portions of this to be allowed to be used. I'm going to allow slide 2. Go to slide 10 so everyone sees it. 10 will be allowed. 11, 12, which shows no unknown contributors out of fairness to the state, and then slide 13, where that shows an untouched Bodie report as to relates to not only the people that were excluded at locations, included at certain locations, but it also allows for the state, as it relates to the reliable results that were testified to, that he has a document that is not that has not been touched or altered in any way. Mr. Decker, I understand from your perspective that how do we have the defense to have certain charts to be available when the state does not. It's the court's position, right, wrong, or indifferent, but the court's position is that the defense's theory in this case deals with the issue of Corey Caneiro. The court finds that there is, whether there is a rational basis or not, is not for the court to decide, but that it was testified to. I'm going to allow it for this limited purpose, but I will also give you the ability to address that any way that you need to in your summation.
Thanks, Judge.
So it's 2, 10, 11, 12, and 13. Yeah, that, Mr. Murray?
Yeah, so that's what can,
That's
in evidence.
2, 10, 11, 12, 13 in evidence. The rest of the slides are out.
Can the additional slides be commented on?
Did he just get mad?
Part of a PowerPoint for closing?
Well, they're not in evidence.
Right.
So they can be discussed, but they're not in evidence. So they shouldn't be on the screen. But these, you have carte blanche to do whatever you want with.
Okay.
He's right here.
210, I'll show you.
Oh, not this.
Just for the 2.
This one?
Yes. 10, 11, 12, 13.
Can you just go back for a second?
Sure. This is it.
Oh, no, nice. Judge, can this one be admitted, which shows just the alleles that are unique?
I've already indicated my position as it relates to the items. I know you asked to put them all in. I'm not putting them all in. I find them to be cumulative. The one provides the coloring that shows the differences and also the shared alleles for each one. And so I'm allowing one of those documents, and that's the one that I'm allowing.
I predict she's going to write up her own display.
Mr. Murray, any other
She'll write it up. Remember, like she did during the trial?
Between 145, I guess, and 150 or 151 beyond that I'm unaware of that you're attempting to move. And then I need an updated exhibit list from you by tomorrow morning, please.
So other than that, the slideshow, I don't think I can ask Ms. Massimo, but I don't think we're moving any of the things.
Just the photos.
We can't hear him at all.
Yeah, but no documentary exhibit, so that would be it.
That's
I
it.
think it was 50.
Okay. All right. So now we can go to the defense photos. Have they been reviewed and agreed upon, or do we have certain ones that I need to address?
I don't think there's any objection to any of the objections.
Okay. We should, for the record, though, Mr. Murray, we have to put them on the record as to what numbers that they are.
I can do that now.
Yeah, whenever you're ready.
I don't need to do the point exhibits, do I? I mean, I can.
No, if you're saying, is the agreement to include the .1s in what you're saying?
I looked at the .1 exhibits a little while ago. There was one that was duplicative, which I told Ms. Mastalone. I believe she took it out, but otherwise they're fine.
Otherwise, you're good?
Yes.
Okay. So you don't, Mr. Murray, you don't have to say slide 1, 2, 3. If it's slide 1 through 30 that are in, then you can just say that. But you tell me. I don't know what you're going to say. So go ahead.
Take your time. Go ahead. It's like defense didn't plan for this stage of the trial. They're struggling right now. What are we going to do? I think we might wrap this up. There's nothing
Okay, so I think
spicy that's going to happen here other than arguing over pictures.
as of now, and the point ones are, I guess we'll do the point ones next, but
okay.
This is, so we have, these are all D1 exhibits, so 1, then 6, 7, 9 through 12, 15 through 17, 21, 27 through 31, 34 through 38, 41, 43, 44 through 66. But we need to, there's no 1-50, but other than that, 44 through 66, but there's no
50.
There's no 50.
Okay.
71 through 75. 79 through 97.
I'm sorry, I'm just trying to keep up. I want to make sure we have everything. Did you say, where did you end up with the 60? 66?
66, yes.
Okay, and then we are at 71.
She's like,
72,
she interrupts her own
75.
co-counsel.
Okay.
I'm sorry.
Yes.
And then it's going to go 80.
We had 74 too, right?
Yeah, 74.
71 through 75, yeah, to include 74.
And then 79 is going to go all the way from 79 through 97. We have 100 and 101. We've got 116 through 127.
116 to 127?
Yeah.
Okay.
Andy?
Yeah.
122.
There's no 122? Oh, I'm sorry, there is no 122 on our list.
No 122. Okay, no problem.
127 is our, okay. And then after
Sorry, I just find it funny that they're disorganized at this point.
136, 137, 141. Then we're going to go to 145 through 152. 166 through 169. 172, 73, and 74. And then jumping to 200 to 206.
She's flipping through these pictures
208,
in real time.
210, 211, 214, 216, 224, 226 through 231, 235, 36, and 37.
She just hands off a stack to Paul.
240 through 245. 251, 252, 254, 255, 256. Oh, this is, okay, so then 257 through 262, 264 through 2... I believe it's 264 through 287.
I'm looking at the pictures. Now looking at the pictures from inside the burned house.
281, 282.
No, I'm sorry, I don't. I have 80 to 83. So, except for 81 and 82.
Okay.
291 through 293. We're going to 300, 301, 303, 304, 307 through 309, 311, 317, 317A, 318, 318A, 320, 321.
Now looking at the target practice stuff, the laser targets, infrared, night vision, a knife.
400 through 403. And then we're to end, we're going to have 420 through 430. And there is one issue is that I think 423 was that screenshot of my notepad. So I don't know if there is an actual 423 or if it's just a 423.1.
Oh, if you didn't mark the back of your notepad, it would just be the 1.
I think it would just be the 1.
0.1.
Okay, so I'm going to take that out.
423.1.
423.1 would be it. 423 is not it. Yeah,
All right. I just wanted to see them get through that. I think we're going to call it right there. It's been a fun day. It's been a crazy day. We've got all the breaking news from the Nancy Guthrie investigation that we now have pictures of one, possibly two suspects that were captured on Nest cameras outside her home prior to the believed abduction. What is RA shopping for on Amazon over there? Oh, these are. I was actually looking at pen lights because people were on Twitter, people were saying this is a. Let's see if I can show you this. This is a little squeeze light, and I said it's not a reflection of like gold teeth or a grill. He's holding a little pinch to activate LED light in his mouth. It gives him hands-free and light access when he needs it. So I was just looking up those. They're dirt cheap. I think you can get them for like 10 for $7 or something. Closings tomorrow. Cables. I'm always shopping for cables. I am getting cables. I'm shopping for cables on this computer over here. That's where Sweetwater is. Just going to add a couple more things to my cart, and I need some shielded Cat 6, 200 feet, terminated both ends, RJ45s. So need that as well. But all right, that's where we're going to pick it up tomorrow with maybe some jury instructions and closing arguments, which are going to be very interesting as both sides try to put together the evidence that the jury has heard over these couple weeks and assemble it into a clear, easy to understand package that points them towards the conclusion that they would like. 90% of us think that the state has done the job and proven Paul Caneiro guilty on the charges he's facing. 10% have reasonable doubt and or just don't believe they've done it, don't believe he's guilty, one of the two. So big thanks to our incredible moderators, including Greeners. Greeners just on board, making himself at home in the amongst the moderator tools. Thank you, my friend. I never even reached out to you to see if you were cool with this. How do you like it, Greeners? Honestly, is this something that you might be interested in continuing to do? He's very at home. Moderators, you can weigh in publicly. Veto power, come through right now if you need to change. Heather, I believe he's guilty. I believe Paul's guilty. Things that just did it for me. His car, the time frame. His car drives over the middle of the night. They've got him in all the different security cameras in a very, very specific, unique car that's not extremely popular in that area. Driving over there and back, it just does. There's too much. There's too much that just doesn't add up any other way. I'm quitting if we get rid of our Greeners. We'll take it day by day. Well, Greeners, we're glad to have you. So we're gonna keep you with your shield for the time being. As always, no one has to be a mod if they don't want to be. So nobody got a timeout today. See, he's exercising restraint. That's what it is. All right, we're gonna wrap it up here. Thank you all for being here. Thanks for amazing mods. Thanks to all of you for making this the fun place that it is. When we come back tomorrow morning, what was the time for their starting? Does anyone remember? When we come back for tomorrow morning, we expect closing arguments in court and deliberations. We may even get a verdict tomorrow. That's a possibility. If we do, it's going to be an evening one. Let's see what the judges say.
All right, we've gone over the charge. Everyone has the final draft?
Yep, we're good, Judge.
It's been marked as C9. All the other drafts have been marked and will be preserved.
Everyone's packing up and ready to go. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again tomorrow morning. I think it's 8:30. I think it is 8:30. Joe, thank you for that. And we'll be back. I can't wait for closings. I want to hear the two sides going at it one more time as they try to sway, the defense only needs one. Prosecution needs all 12. So we'll see how this goes tomorrow. You guys be good to each other. We'll see you in the morning. Have a good night. Bye-bye.
You're talking about stuff that is not relevant. What more do you need to see?
there's nothing in the order that restrains you from talking to cats.
Thank you.
Hush! Now I'm trying to have court. Don't raise your voice again.
Thank you, sir. You're my new best friend.